by Lady Justice Kavetsa. Why then would any court go against what they have submitted? In fact, we will have requested for 10, but we have increased it by 4 to 14 days, as per the case law. I need also to mention on case laws, since it has been mentioned, and all the case laws, the Good Counsel has mentioned the offenses. Your Honor, there is a presumption of innocence to anyone who appears before any court. My lady, these presumptions assumes that anyone who steps under this place is innocent until proven guilty. My lady, based on this, there are several cases of the fact that you cannot rely on a specific charge to determine for the DPP to now claim that they need 21 days because it is a speculation of murder. Just to add, and my lady, for the benefit of the public, it is important that miscellaneous applications are not used to harass or intimidate any persons in Kenya. By a matter of fact, I might leave this court and be arrested for an attempted murder and be brought, and they might request for 90 days. But it is speculation. It is therefore our admission that 14 days is reasonable enough for them to conduct the investigation. If they have any funds which we have already submitted, if they require more funds, we are ready to submit. My lady, finally on the last part, under the prayers, they have requested for DNA samples. Which we are ready to offer today, because we believe those are the any other investigation, including searches. We are ready for them to be done at any time that the DPP are willing to conduct it. Under prayer B, my lady, because I do not have a right of response after this, they respond in a different way. So I'm just speculating. In the event the court allows them to be held under different police stations, because they have requested the first respondent to be held at Mudangari and second at Kilelesho. Shows the line in which the investigation is taken. But my lady, we are willing for them to be held at those police stations. However, this weekend we have faced a challenge, even speaking to our client, the first respondent. We cannot get proper instructions from him, because apparently the police station have orders for him not to speak to us directly unless they have been brought to court. My lady, if that is the case, We pray that when he's held at that specific police station, we can get express orders for the advocates and the family to have a direct access, which is his constitutional right, anytime and upon a reasonable time, which I believe is 6 to 6. To have a talk with the first respondent. Also for purpose
Yes, we do have some brief submissions. You will also note that Council has indicated to the court that the respondents will be willing to be detained for 14 days. Okay. I'll start with the right to bail. The defense has submitted that right to bail is a constitutional right. And on our part, for the state, we do submit that yes, it is a right, a constitutional right, but it's not a right that cannot be limited. Your Honor, the Constitution provides for limitation of this right, where the state has demonstrated compelling reasons. It is our submission that the state, through the application that we have filed in court, will be able to show to this court that we do have compelling reasons to warrant the detention of the suspects at the police station. In response to paragraph number 9, as the defense has pointed out to the court, our paragraph clearly states that the respondents participated in the offense. So the averment that they did not participate is neither here nor there. We will also like to submit that it is true the respondents were arrested and were in the police cells in relation to a different case. It's not this case that's before you. They were arrested for having committed an offense of preparation to commit a felony. And what is before you, Your Honor, is a totally different case that relates to a murder charge. We also meeting in connection to that the suspects, as you look at our affidavit, were arrested at the police station. So for that case, we are not aware if they have any fixed place of abode. For us, it is our submission that they are flight risk. We do not know their places of abode. We cannot confirm to this court that we know their fixed place of residence. We also submit to the court, Your Honor, that even though the respondents are civilians, we have pointed out that this is a complex case. It involves the participation of officers of the National Police Service, and these officers are likely to influence the respondents so as to interfere with the investigations that are still ongoing. Your Honor, back to the case that we have quoted, the Mwangangi versus public case, we do submit that the circumstances in that particular case were totally different from the circumstances that are before you now. Your Honor, with those submissions, we want to confirm that they have also not recorded their statements, and we require them to continue being detained for purposes of statement recording. With those brief announcements, we still reiterate our application that the respondents be detained for a period of 14 days to enable us now conclude our investigations.
You have considered?
Yes, we have considered 14 days.
So we can resume at 2:15. Overruled. Question 215.
Just for clarity of the record, can it be officially indicated that the DPP has indicated that
Kutumia